Hello, everyone. Thank you for joining this webinar. We are going to be talking about our latest Spotlight report on attitudes, respect and rights, relationship of equals. We do have some people joining us kind of as we go through. The session will be recorded as well, so you'll be able to get a copy of that afterwards. So don't worry about taking too many notes. I see that a couple of hands have gone up, and we would ask you to do is, if it's okay, is to put your questions in the chat or using the Q&A, and we'll try and get to them after the presentation, if that's okay. We're joined by Richard Blakeway this afternoon, the Housing Ombudsman, Rebecca Reed, Head of Insight and Development, and Zoe Miller, who is a Insight and Development Manager. We are going to kind of hear a quick intro from the Housing Ombudsman before we go into the presentation, and then we'll do the Q&A after that. So without further ado, I'll pass to Richard, and thank you very much. If you have any other technical queries, then please do put them in the chat. But what I would suggest, if you can't hear or see, is to leave and then come back in again, and that should reset it and it should work. But please, Richard, over to yourself.
Cool. Thanks, Mark, and welcome everyone, and thank you for joining. But I also wanted to say thank you for responding to the call for evidence that we did last year, because I suspect a number of you who have joined today's webinar will have participated in that, and it was an invaluable source of insight as part of the development of this report and the recommendations that we made. And obviously, our report deals with issues that have been talked about for a considerable length of time, but we wanted to bring a real focus to the critical role that social housing plays, but also how that role has changed over the years and how that's reflected in the nature of the cases and type of cases that we receive as an ombudsman and the decisions that we make. So we very much hope that the recommendations that we made will be practical for landlords, but also thought-provoking for policymakers in terms of the future of social housing, given how important it is for residents and landlords and society as a whole. We'll obviously have the presentation and look forward to your questions. I'm going to leave it there and hand to Rebecca.
Thank you very much. This is where I pass my first test, hopefully, of being able to share my screen correctly. I'd appreciate a couple of thumbs ups, people, if that's okay, to confirm that it has shared properly. Thank you, Richard. Really appreciate it, because I can't now actually see the screen, so that works really well. Right, so allow me to introduce myself. Like I said, my name is Rebecca Reed. I'm the Head of Insight and Development. I will stress now that Zoe Miller is the author of this report, and that is why she's here today to answer the questions. And I will also stress now, please read the report. Don't just rely on this presentation for getting the nuance and the depth of what it was that we found during our investigation. I haven't got time today to go through all the case studies, but they are by far the most powerful aspect of our report. So please do go and read the full report if you've not had the chance to do so yet. So, why do we do Spotlight reports in the first instance? And that's worked brilliantly. It hasn't clicked through. There we go. It's clicking through now. Okay, so Spotlight reports, for those of you who've never attended any of these webinars before, they are the primary purpose of our Spotlight reports publication scheme is to promote learning from the complaints that the Ombudsman Service sees. So it's about pushing. We deal with thousands of cases every single year, and every single one of those cases has the potential for learning for the sector. So the point of Spotlight reports is to pull that all together and disseminate that learning back into the sector, because we're seeing the themes and trends in the cases that we're handling, and that allows everyone to learn from what's happened in the past so that hopefully it doesn't happen in the future. So they are deeper investigations into systemic and thematic issues. Rick's alluded to the call for evidence that we did last year. We really do a deep dive into something to find out why what we are seeing is what we are seeing, and promote the learning back in to ensure it doesn't happen again. We do use focus groups, we use calls for evidence to inform the findings. So we speak to the people who handle the cases now, who are the experts in the areas that we're investigating, to find out what's going on and make the best recommendations that we can. So we speak to sector experts, we speak to landlords, we speak to residents as well, and we do consultation with everyone who can give us information. And as we will allude to for this one, we spoke to a lot of academics as well, and we did a lot of research about demographics and information about people in general to inform our recommendations. We make recommendations for actions at all levels on our Spotlight report. This one's no exception. We've gone for the Royal Commission this time, but we have always made recommendations for every level that needs things that we think they need to do in order to improve the situation. And then we don't walk away from these. We do ongoing monitoring. We've published a follow-up report on the damp and mold Spotlight a year later. We're in the process of just checking out what's happened as a result of our noise Spotlight a year later. And this one will be absolutely no different. Same with the knowledge and information management that we published last year as well. So why did we choose this subject? To be honest, it's almost easier to list why we wouldn't have chosen this subject. It would be a shorter list. We have seen an increase in complaints about contact restrictions. We've seen an increase in complaints about how people have been behaved towards by staff at housing associations and local authorities. We've seen refusals to consider complaints. We've seen refusal to engage with complaints. So we've generally seen poor service towards residents seeking to raise a complaint. And then the cross-cutting themes as well are and I will go on to the statistic later on, I'm not going to steal my own thunder, but the number of cases we see where they might be complaining about a leaky tap or what have you, but communication was a major facet in the complaint as to why there has been dissatisfaction with the experience of reporting that leaky tap. The behaviour of the member of staff or the operative that attended to fix that leaky tap is often part of a cross-cutting theme as well. And then we have also seen allegations that there was bias, prejudice, or discrimination in why what happened. Even if that's a perception, still that is raised as an issue within the complaints. It's also, just to stress as well, this aspect of a relationship between the landlord and residents has been a recurring theme in all of the Spotlight reports we've published to date. So again, it's about continuing that golden thread through our Spotlights of building on what we're seeing in a particular area and then developing it further. So it really was quite a call to arms for this one in particular. The research that we did in order to inform this investigation, we looked at the determinations made in a 14-month period between April 2022 and June 2023. We did a call for evidence. I'll go on to that in a bit more detail. We did a lot of reviewing of academic research, government research, charities, private sector research, anything that would inform the demographics and the information about what we're seeing, but also using the research people have already done in this area to inform and explain what we were seeing and putting it in context. We've also used government statistical data, including the census reports as well, English Housing Survey, all sorts of statistics, you name it, if it was out there, we went and had a look at it. But to give you a bit of context for the situation that we are in and the operating environment that the social housing sector is in. So between 1945, when the entire concept was created, and the 1980, 4.4 million social homes were built. However, from 1980 onwards, 2 million was sold. Now, okay, there will have been some more that have been built in between 1980 and now, and that may form part of that 2 million, but you are looking at the fact that approximately just under half of the social homes built in that 35-year space have now since been sold. So that's to give a context of it. There are consequently longer waiting lists. There is more overcrowding in social homes than in any other kind of housing, be that private rented, be that mortgage owned, any other kind. The highest level is in social homes. And 54% of social homes have at least one resident with a long-term disability or illness. And on average, social renters are older than people who are privately renting as well. So you're starting to see the demographics at play in the operational landscape of social housing. This is taken from the statistical return from the Regulator for Social Housing, and it's a really stark illustration of the reality of the proportion of housing within the social housing sector. So as you can see on that graph, 3/4 of social housing is labelled as general needs. Now, I will come on to that in quite a bit of detail, but then you've got affordable rent, which is still general needs, so that takes that up to 83% in total, and only 11% of the social housing portfolio is what is termed as supported housing, and that is for someone with a clearly defined need. And then you've got 0.5%, which isn't even mentioned, is also supported housing. So it's 11.5% in total. It's not very much. This is the ratio of allocations that happened this last year on social housing. So the sorry, bear with me. I've just got to find my notes on this particular section. I've managed to copy and paste them from one place to the other, and so I'm struggling to find them. So the regulated statistical turn, only 11.5%. In 2021, 27% of the lettings were for supported housing properties, despite that only being 11.5% of the housing that was available for rental. 43% of single elder people ended up in general needs accommodation. That's 64% of elderly couples ended up in general needs. 73% of homeless applications were put in general needs, and 66% of disability or access-related housing needs also were in general needs. 65% of members with a long-term illness, general needs. But if you look at the list of supported housing versus general needs and the types of demographics that are going into it, you can see there really isn't much difference between the two. So you have a reality that the demographics that present as being the kinds of people who would be given supported housing are usually, because of the sheer volume of supported housing that there is not, going into general needs housing, which is why we have said very clearly in our report, general needs is not no needs. It's just that they do not hit the markers for being given supported housing. So it's really important that there is a recognition that general needs housing contains people that have needs of some variety. And this is a landlord's responsibility to ascertain what those are. So, call for evidence. This is where we went and asked, like I said, we asked 5 questions, and I will just go through what those 5 questions were, because I managed to miss doing that at the beginning of the slides, which is my fault, I beg your pardon. So we asked what the barriers to effective communication were. We asked what the main issues advocacy services are asked to support residents with, and whether they'd seen a request for increasing requests for assistance. And we asked for residents' experiences requesting reasonable adjustments. And we also asked these questions here about how well informed are you kept by your landlord about these particular topics. And the one that really stands out is rent and service charges. 78% of residents feel that they are being kept adequately informed about rent and services charges. It drops down to 26% for decisions that affect their homes. That's really stark. A third of those people answering the charges, the questions that asked about whether landlords give a good information about their charges, said that they give a very good explanation for how for about their charges. And more than one resident said they felt like they were just a cash cow, and that for everything else they weren't listened to, but when it came and weren't communicated with, but when it came to rent and service charges, they really were. So again, it's just a really interesting statistic about the level of communication really differs depending on the resident's perception of whether or not it's in their landlord's best interests or not. So the other question that we asked in our call for evidence was about accessibility. So 58% of the people who responded to us from the resident population had a disability of some variety or other and considered they had a disability. Only 19% of that 58% of people said that the landlord had made reasonable adjustments for them when they'd asked for it. Admittedly, 5% of those residents said that they'd never asked for any reasonable adjustments, but a whopping 68% of the 58% of the people that replied said, I have a disability, I've let my landlord know about it, and they did not provide the reasonable adjustments that I asked for. Many respondents referred specifically to the lack of aided adaptations that have been put in their homes, and that reflects the English Housing Survey findings that over half of housing association tenants lack the adaptations that they need. So again, like I said before, we went and did a lot of research to back up what it was that we were finding. A really strong theme in the resident responses to the calls for evidence was about digital exclusion, unequal access or capacity to use digital technologies. And this is also reflected in the English Housing Survey findings. 17% of social housing homes have no internet connection. And they are the least likely of all types of homes situations to have internet access at home. So again, you're looking at the fact that there are 17% of social homes who do not have easy access to the internet, and that leads to digital exclusion. If letters, notice boards, face-to-face have been reduced. So many resident respondents reported a one-size-fits-all approach to communication. Frequently, they referred to the fact that digital communication was the only option given to them, and that didn't satisfy their needs. And it often didn't reach the entirety of the intended audience and failed to consider personal circumstances. So like I say, no more letters coming out, estate notice boards being discontinued, and face-to-face contact dropping off, leading to people to feel excluded and unable to readily access their landlord. Another theme was the difficulty some residents experience when trying to contact their landlord. Again, same thing. If it's all via the digital forum, if there aren't the phone lines, if there aren't the walk-in locations, then people can't get in touch with the landlord. And advocacy agent services were often approached to assist residents with effective communication with the landlord. Landlords replied with what their barriers were for communication. And as you can see, lack of resources was top and front and centre. And we do acknowledge that. Lack of resources included a lack of time with increasing workloads, no customer relationship management systems, so the databases weren't quite where they needed to be in order for people to be able to do their jobs efficiently. Inadequate records of communication preferences. So again, they didn't have the details of whether the person preferred to be spoken to by letter or they preferred to be spoken to by phone. And sourcing translation for documents for people whose English wasn't their first language. The landlords themselves acknowledge the digital exclusion of residents is a problem for this day and age. So on both sides, everyone is registering that using the internet is the main source of communication. Whilst it works for a lot of people, it doesn't work for everyone. Some of the things that were said was that they have previously had communication come through partnership working with colleagues like the community mental health teams. That doesn't happen anymore. The other declined provision of social care and the provision of social statutory services by local authorities and third sector parties also means there's an increase for landlords to manage increasingly complex situations on their own without that professional support that would previously have come from those agencies. So again, landlords themselves are recognizing that there is a lack of other backup systems for communication, and it needs to be more directly through the landlord as well. Two landlords, interestingly, did cite GDPR. That's the General Data Protections. It's basically not sharing data unless it's legal to do so. Cited GDPR as a barrier to communicating with residents, specifically that the definition of legitimate interest presented challenges to communicating with residents about support and services they may be able to provide. So again, there's some potential confusion there about whether the legislation allows landlords to have communication and conversations in the way that they would prefer. Another landlord talked about psychographic segmentation, which sounds painful, but it is about mapping people and using the information that you already have to then decide what is the best way of communicating with a person. So they use that analysis of a person's characteristics to map out what might be the best way to communicate with them. Advocacy services replied to our call for evidence as well. And as you can see, the phenomenal rise in the main issues that they have been asked to support residents with is in repairs, which includes damp and mould. They have attributed most of this rise in support requests to the current cost of living crisis. And the English Housing Survey 2021 to 22 found that 74% of social renters have no savings, compared to only 48%, which is still quite high, but 48% of private renters and 18% of social renters are in arrears, either currently or within the last year. So again, it's quite clear that the cost of living crisis and cash flow has a significant impact on things. Several advocacy respondents referred to the difficulties some residents feel in navigating telephone call centres. So again, we talk about digital exclusion, but sometimes phone calls aren't the answer either. And similar to residents, advocates also raise concerns about the reliance on single methods of contact. The benefits of in-person contact and support for vulnerable residents was stressed by them. A simple knock on the door to check in on residents can help maintain and improve the landlord-tenant relationship. And I've had conversations with landlords recently who've started to reintroduce that kind of face-to-face ad hoc contact into their service. Landlord respondents also raised the lack of face-to-face service provision as a problem. To go back to the previous slide, it's there as well. Highlighting that a lack of resources and increased demand on this service was a barrier to personal contact. Many advocacy agencies unfortunately describe the attitude of social housing providers in less than flattering terms. Some said housing officers have become completely disillusioned with the work that they do. Another said landlords can be obstructive and reluctant to carry out repairs. So again, the advocacy services have a perception of landlord service that isn't necessarily customer focused and putting the customer first. There's a perception amongst advocacy services respondents that landlords are not interested in responding promptly to complaints, and residents face difficulty getting listened to. So I'm now going to talk about what our case data told us as well. It's worth saying from the get-go that we excluded any cases from this analysis where the service delivery was impacted by the COVID-19 pandemic. Those were exceptional circumstances. They are not reflective of a normal operating environment, and as a consequence, we haven't included these. The 353 cases that we analysed were all determined within those 14 months, as I said so before. There were 193 findings on those 353 cases that were relating to staff conduct, and there were 171 complaint handling findings on there as well. On the staff conduct, the highest amount of compensation that we ordered was £1,000, where the Ombudsman found that the attitude and approach of a housing officer adversely affected a suicidal and disabled resident, and their subsequent failure to adequately respond to the complaint then prolonged the distress that the person was experiencing. So we have ordered £1,000 for an individual's behaviour and conduct towards a resident before now. 31% maladministration rate, though that is actually down the lower end of our maladministration rate. So that example is thankfully the exception, not the norm, but it's worth saying that 31% is still really quite high. That's a third of allegations that staff conduct was unfair or unreasonable or distressing was found to be the case as well. That's over £14,000 of compensation across those 193 staff conducts. And those of you who are excellent maths will work out what that roughly is. Off the top of my head, that's £700 per finding. So again, that just to give you a context. For the complaint handling cases, whilst these complaints were not necessarily from vulnerable residents in and of themselves, approximately 40% of the residents in these particular cases who complained said they had a disability or a vulnerability that they were experiencing. So again, this is just reflective of the reality of the operating environment and the level of potential vulnerability, either temporary or permanent, that any given person has at any one time going through either the complaint system or requesting a service provision. 68% of the cases that we handled in that 14 months had communication as a cross-cutting theme. So just to explain what a cross-cutting theme is, it's not necessarily specifically the thing that the person has complained about, but it's a facet and an angle within the complaint that they have made. So to use my leaky tap example, the complaint is about the service provision on the leaky tap, but the manner in which they were kept updated about the repairs is a cross-cutting theme to the complaint. So hopefully that gives you a bit of explanation. 68% was 2,425 cases. So that just gives you an idea of how many cases are coming through our hands where communication is one of the key issues within that complaint. Staff and operative behaviour was directly complained about, and ASB and property condition are the kinds of topics of complaint where the communication is a major facet in it. For 325 cases with staff operative behaviour, as I said, they were predominantly around ASB, and they were also about property condition as well. Bias cases, the majority of these complaints were about ASB or about staff conduct. So again, you're starting to see that where there are issues around differences of opinion about whether something is serious or not, staff and operative behaviour and bias starts to become a facet of people's perception of the service provision and whether it was reasonable or not. 44% maladministration rate when someone said that a staff member or an operative behaviour was part of their complaint aspect. 36% maladministration rate when bias, prejudice or discrimination was part of their complaint as well. And as you can see, for the bias, prejudice and discrimination cases where we found maladministration, the compensation awards were appropriately high. Over £1,400 of the 32,000 listed there relates to landlord failures to adequately investigate allegations of bias or discrimination. So again, that is a rallying call. If a resident is asserting that there is bias or discrimination in how they were dealt, it's really important to tackle that allegation head on and get to the bottom of whether there is any bias or discrimination, unintended or otherwise, in what has happened to the person. Okay. Now I'll get to the meat of these two, and these are long slides, and I make no apology for that. Our key findings boils down into two topics, and I wouldn't want you to think that because the people section is commensurately, there's only 3 words in that, and there's a lot more in processes, that wasn't because those 3 words summed up the core things of what we found. So people in this context means the behaviors of individual people, landlords, staff, their attitudes, their belief systems, tone, approach, dismissive attitudes, that sort of thing is everything that we mean by people in the report. We found a phenomenal amount of insensitivity in the day-to-day communication between operatives and staff members of landlords with residents. Terminal illnesses were discussed in brutal terms at times. We had at least 2 cases where people had lost people's ashes for the families concerned, and they didn't know where they'd gone. We saw dismissal of antisocial behaviour. There was one particular one where a landlord actually turned around and said there's no evidence of any antisocial behaviour at this particular property, where the issues being complained of were actually going through the court process as they spoke at the time. Callousness towards bereavement, comments about lifestyle, blaming residents for the situations that they found themselves in, judgmental attitudes about how people are living their lives in the homes. All of that was insensitive, it was dismissive, it was offensive in the way that people were communicating on an everyday basis with their customers as well. Regardless of the demographics involved and regardless of the type of service provision, it's really important to say that it wasn't limited to the repairs teams. It wasn't limited to the customer contact centre. It wasn't limited to particular demographics either. It was across the board, from allocations through to repairs. The manner in which the landlord communicated with or failed to communicate with was the resident. We saw lived experiences being dismissed. We saw accusatory tones, and then as you might expect, these particular attitudes and approaches are what results in the allegations of discrimination or unfavourable treatment, consequently in the answer to the service provision. And then this was compounded by the failure to give respect and recognition to that allegation, as I said before, and actually investigate the allegation that there was bias or discrimination in what happened. Where a resident already feels they're being treated unfairly, and then the complaint of unfairness is ignored, partly responded to, or the response is hostile, that's just going to reinforce the view that there was unfairness in the situation, and that will undermine their trust or the faith in the landlord, and it will cause a relationship breakdown. So particularly on complaints handling, restoring that confidence when someone says they feel like they've been discriminated against becomes incredibly important. Processes. Processes in this shorthand refers to the external and internal frameworks that the landlord adheres to, like policies, procedures, but it's also legislative and regulatory requirements. We recognise that landlords have an obligation to act in accordance with the legislation and with the regulations. They develop policies and procedures in order to allow them to do that, but sometimes those policies and procedures and processes cause problems as well. So the failures we found in our casebook were either a failure to act on vulnerabilities because they weren't recorded in the system, or where they were recorded into the system, a failure to take those into account when making decisions or providing the service. Many of our findings of severe maladministration were made in cases where the resident was vulnerable, and that compounded the detriment caused by the service failures that they were experiencing. Not all landlords understand their requirements, their obligations and duties on reasonable adjustments, nor the importance of these adjustments to residents. I can't stress this enough. In over 200 cases that we reviewed, we didn't see a single example of reasonable adjustments being implemented well. That's stark. We commonly see a short statement in the complaints policy stating the landlords acted in accordance with the Equality Act, but find that the landlord then can't evidence how that happens, and they can't evidence how they respond to requests for reasonable adjustments, and complaints handlers have had enough appropriate training to be able to handle reasonable adjustment queries. Where the specific policies were in place, they weren't adhered to. And we found examples of landlords failing to identify requests for reasonable adjustments, or proactively identifying that the person needed reasonable adjustments made. So, because it shouldn't just be that somebody's asking for them. If there's a clear need for reasonable adjustments to be made, then those should be acknowledged, identified, and acted on. Where reasonable adjustments were recorded as required, they weren't always enacted, which is, if it's in the database, that's great, but if no one's doing anything about it, it's pretty worthless. The failure to adhere to the policy often hadn't been identified by the landlord before actually the case got all the way to the Ombudsman service. So what you're looking at there is that the complaint was made, that my reasonable adjustments weren't adhered to. They didn't notice the policy hadn't even been adhered to during the complaint handling, and it wasn't until it came to the Housing Ombudsman service that it was identified that they hadn't adhered to their own reasonable adjustments policy. Discrimination. Thankfully, there were not very many examples from our casebook where we had to refer to the discrimination guidelines. And obviously, we are not the body that adjudicates on whether discrimination has occurred, but we can absolutely use the guidance in our own cases as reference. However, the cases that we did see of this nature have been extremely concerning, and there's been significant impact on the resident and potentially multiple breaches of legislation. We saw one example of a person who was not allowed housing because their passport didn't match, and they were told that they weren't believed that they were married. That is a very basic one, but that is as fundamental as that. That is discrimination on the grounds of marital status, and it's unlawful. We did see some good examples. We saw a gentleman who alleged that there was racial discrimination in the way in which rent and services charges were calculated for his block of flats. The full investigation carried out, shared the steps taken, shared theirs, and directly addressed whether the differences in service charges were divided along racial lines, and gave explanations for why the service charges were different for the different flats within it. So they addressed the allegation head on. They didn't shy away from it. They said, you are alleging we're discriminating on the grounds of race. We are going to look into why there is a difference, and we're going to get that explanation to you. That's a really good example. We've seen from our casework that landlords are sometimes, so the contact restrictions. We know that landlords are sometimes subject to unwarranted, unpleasant verbal abuse. It's not right, it's not okay, it shouldn't be accepted, and even threats. But sometimes, and we also know that landlords can get excessive contact from residents, which means that the resources are used on the person that's having a bit too much contact and isn't used on the people that really need it. So we are alive to that. We're not naive on it. You know, every public body has the same situation, and we know it can happen, but sometimes those behaviours are related to underlying problems or vulnerabilities. And so there can be situations where, despite the landlord's best effort, contact with a resident does need to be restricted, and that's okay. But that needs to form part of an unreasonable behaviour policy or process. It needs to have a clear appeals process. It needs to have a clear review process that allows the person to say, this isn't fair, and I don't think I deserve these restrictions. I don't think these are the right restrictions for me, or this isn't going to work for me and my access needs. Clarity about how service requests and complaints can still be raised during the course of restrictions, because contact restrictions do not remove people's rights to raise issues. They just restrict the way in which people can make contact, and whether there needs to be a single point of contact in place to ensure continuity of good customer service as well. We have issued guidance notes on this, and I can only suggest that you go and read them as well. You know, it is a situation and a service provision that all public-facing bodies need to consider. Our casework shows that where we find service area in this area, it's usually because one or more of the key components I've just listed isn't in place, or if it is in place, it's not followed. I know from previous career experience, if you put contact restrictions in place and then don't adhere to them, that sends the message that they aren't to be adhered to, they're not to be respected, and they are essentially deemed worthless. So either not put in place or not followed as well. Contractors. We've seen several instances of landlords not enforcing the contractor's code of conduct. I'm not going to say much more on it, but I will say the next Spotlight report that we are doing is on contractors and that situation. But again, the contractor is the landlord's face when they go into the resident's home. And if the code of conduct is not being enforced, then as far as the resident is concerned, the landlord is the one that is misbehaving in their home. So it's really important that contractors' code of conduct is enforced. Investigations. We saw landlords reaching conclusions and presenting them as fact without carrying out any investigation, or if they did, not being able to tell us what that investigation was, not being able to audit their actions, not being able to show how they'd reached an unbiased, objective decision on their investigation into it. In many cases where it was the resident's recollection versus the staff members, the landlord based their findings purely on the staff members' account without considering whether on the balance of probabilities, the resident's account rang truer or the member of staff's rang truer. True is probably the wrong word to use, but on balance, which one was more plausible? Too often the findings were then presented to the resident in an unhelpful and divisive manner, further impacting the relationship and reinforcing this "it's you versus us" mentality. Landlords were often unable to carry out meaningful investigations because telephone calls aren't recorded. So, very basic, but if there's a conversation and an allegation that on the phone so-and-so was rude to me, if phone calls are not being routinely recorded, that cannot be verified and cannot be checked. And conversely, if the resident's conduct on that phone is unreasonable and the landlord is starting to consider contact restrictions, if the phone call isn't recorded, it's very difficult to verify that indeed the resident was unreasonable in the way they were behaving. So it's a yin and yang situation for recording phone calls. There was often no note of the conversation recorded. So again, you're relying on the recollection of the participants at a later date for how they felt the conversation went. And we all know that we've all been in situations where we've had a really heated conversation with somebody and we've genuinely misremembered what's been said. So if there's no note of the conversation made at the time, it's very difficult to be able to rely on people's recollections later down the line. We also found examples of residents withdrawing from an investigation process because they had a lack of faith in the landlord to actually do the investigation properly, but then that wasn't explored by the landlord. So you've got someone turning around and saying, do you know what, I have no confidence that you're going to be able to handle this situation for me, and the landlord just going, okay, and walking away from that. In one example, we saw the residents telling the landlord she didn't trust them to investigate their ASB. They closed the report on the system as no further action without any engagement with her to explore why she didn't trust them, or any consideration that regardless of whether she didn't want to participate in it, maybe they had an obligation to everybody else living in the area to look into the ASB and see if there needed to be further action taken. We did see some examples of landlords investigating things promptly, fairly, and sharing the outcome with the residents. We had one particular example where the resident alleged a member of staff had made a complaint about her race and her gender, and the landlord interviewed witnesses. They took it very seriously and took steps to reach a fair and informed decision. The landlord did conclude that the statement wasn't quite the way the resident remembered it. And again, to go back to my earlier point, people don't necessarily remember verbatim heated exchanges. But despite the fact that it wasn't quite the way the resident had recalled it, they acknowledged that the staff member made comments that were insensitive and they lacked empathy, and they apologized for that. That's a really good example of an empathetic exploration of something that could have been potentially very serious, but they didn't shy away from it, just say, no, you're wrong, you've misremembered it. There was opportunities for learning. They also took steps to prevent further incidents occurring by addressing that with the individual concerned and making certain that they understood the impact of the words that they had said on the resident. In the cases that we assessed for this report, we saw examples of landlords failing to answer queries or provide explanations about service charges. So again, not necessarily the level of the service charge itself, but the queries and the explanations about why the service charge was what it was lacking. So service charge information wasn't always presented in a clear and accessible format. And we all know receiving financial information, particularly at the moment, can be really anxiety provoking, particularly when it's about the level of debt that is already in place against your home and the potential increase in charges, again, at the moment, particularly with the cost of living crisis. We saw instances of unclear financial information and a lack of explanation, and those gave rise to allegations of discrimination. I alluded to the example earlier where someone believed that their rent charges were different because of their ethnic origin as well. So some really serious consequences to not giving information about service charges in a way that's accessible as well. In one case, the resident raised concerns about how the funds had been used and felt that this was a misappropriation of funds, which is potentially, if that continues, quite a serious allegation. Misappropriation of funds is not good. So rather than a constructive or resolution-focused response, or asking the resident how they'd formed that opinion, or why they were concerned, or what was it that we could help and explain, the landlord's response was heavy-handed, and we ended up finding service failure as well. Because again, people are right to raise their concerns, and they're right to ask the questions that are reasonable for people to be held to account. Complaints. By the time any of these are raised by the resident as a formal complaint, they have already repeatedly expressed concern about the underlying communication, the relationships, or the procedural issues, and they've been dissatisfied by the landlord's response. And I feel like we say this in everything that we do. The formal complaint stage is a chance to redress that experience and to regain the trust. It's a chance for the landlord to acknowledge their lived experience, whether that is perception-based, actuality is something to be explored, but acknowledge that that's the way they feel. Investigate the concerns raised and rectify the shortfalls. Our casebook showed that rather than it being an opportunity to reset the balance, however, and address the issues fully, complaint handling sometimes only served to reinforce residents' feelings that they weren't important, that they were inherently unfair, they were having to fight the system, and that was gross inequality in how they were being treated, and that they didn't get a fair hearing. In particular, we found that complaints policies or processes often excluded complaints about staff conduct. And that's a very specific exclusion, and it shouldn't be there. People should be allowed to complain about the behaviour of landlord staff. Good practice always looks like giving clear explanations, different formats where they're needed, being fair and consistent in the approach. I mentioned before about contract restrictions. If they're not enforced, they're not fair, they're not consistent. Investigating allegations, recognizing and acknowledging where service shortfalls have occurred, either because they're people or process-based, and taking steps to repair the relationship breakdown with the resident. So that was a lot of key findings. Key recommendations. There are always opportunities to learn from others, always, across the board. In every organisation, there is always opportunities to learn. So these broadly fit into three: learning culture for the now, fit for the future, and then the big picture of re-knitting together health, housing, and human rights. So there are always opportunities to learn from other organisations and sectors, and it's really important that social housing looks outside their own sector for transferable learning and good practice, particularly as we've alluded to with the demographics changing in the future. The Fit for Future report is a really riveting read for anyone who wants to see it. Look outside the social housing for transferable learning from people who are already working with the demographics that social housing will have in the future. The police use the THRIVE, it's a lovely acronym, the police are very fond of their acronyms, approach to vulnerability. That's the threat, the harm, the risk, investigation, vulnerability, and engagement. I'm not going to go through it in detail, but it's on the College of Policing's website and it's worth a read. But the police use a model for assessing vulnerability, and they engage with a lot of people who have existing vulnerabilities. So they are a good organisation to look at for learning of engaging with vulnerability. Ofcom have got a guide for treating vulnerable customers fairly. Citizens Advice have got a guide on minimum standard support for mental health. There's a lot out there to go and have a look at and see what maps and what's applicable and what can be used. Raise awareness of the complaints procedure and ensure it's accessible for residents who can face barriers to raising a complaint. This is required by the Complaint Handling Code, and that's statutory now. So ensure the complaints policy permits complaints about staff conduct, attitudes and approach. I can't stress this one enough. It's not a reasonable exclusion. Establish and enforce a clear policy for how complaints about bullying and discrimination will be investigated. And I'll say now that the Independent Office for Police Conduct has got a guideline on investigating discrimination allegations that it's provided to the police. So, you know, that's a good guide to go and take a look at for how discrimination allegations can be investigated. Contact restriction policies must set out clear timescales, reviews, appeals process. They can't carry on indefinitely. They need to be reviewed. Is this individual now engaging with the landlord in a way that's appropriate, and actually we can remove the contact restrictions? Are those contact restrictions inadvertently limiting their access? Do they need to be changed? Do they need to be modified? They should be constantly reviewed on a set timescale that's been communicated to the resident so that they know that they haven't been forgotten about and that this is something that they are actively being monitored on. If there is a single point of contact, that needs to be applied consistently, and calls need to be recorded, either a physical recording or a contemporaneous telephone record. Again, relying on human recollection in the months to follow is not a very good way of investigating a phone call conversations. And again, if we're going to talk about that digital exclusion means that there are entire demographics that will prefer to speak to people on phones, you need to make certain that the audit records for telephone conversations are just as good as they would be for digital. Ensuring disability or language needs are routinely considered as part of a complaints process. Again, it's about communication. The complaints process needs to be an even better form of service, if anything, in order to regain the relationship with the resident that's been lost during the service provision. And that extra accessibility support or accessible materials are offered where appropriate. Fit for the future. Culture, vision and values. This is a theme through all of our Spotlight reports. Review the mission statement to ensure it's reflective of the current and the future service. So does the mission statement actually adequately capture what is the mission of social housing for now and for future? Bearing in mind, we know where the demographics are going. Consider at board level if you are assured that the current approach to vulnerabilities is actually working. Do you know who your vulnerable residents are? Do you know where they live? Do you know what their needs are? Undertake a review at board level as to whether you're currently offering a human-centric service provision. So actually, yes, you're providing a service. Does it put the person who's living in that home front and center? And if there are good reasons why it doesn't, are those articulated? If not, identify the barriers to that and what needs to be changed in order to introduce and then embed that culture and that ethos. Consider adopting a values-based recruitment model to ensure resident landlord relationships. I've had a number of landlords approach me anecdotally at various events and say, we did a recruitment drive X decades ago, and as a consequence, we don't necessarily have the people with the right values in that resident landlord interface to deliver the best service. Consider that a values-based recruitment model is a way of ensuring that the people who are being recruited to frontline contact roles with residents will have the right kinds of values to give that really good customer service. Landlords need to ensure that they provide clear explanations, repeat information where it's needed, including in different formats, offer face-to-face contact wherever possible, and a named point of contact. People like to know who it is that they need to speak to. Investigate concerns and share the outcome. Recognize where things have gone wrong, apologize, and explain how it's going to be addressed. Know when to make appropriate referrals to agencies and who to signpost to ensure that people are looked after. Underpinning all of this should be a baseline of empathy and respect. So although it's important for landlords to know the vulnerabilities and individual circumstances of their residents and the associated legal duties, this needs to apply to everybody because fundamentally it's a high standard of customer care and a human-centric approach to service delivery that's absolutely critical to social housing. Vulnerability strategies. So if you haven't got a vulnerability policy already, please put one in place. Review it in conjunction with current practice. Is it being implemented? Is it actually being actioned? If not, where's the disconnect? Why isn't that happening? Be curious about that. Implement a vulnerability strategy, including how it's defined, Who assesses that? What's the review process? Consider the Equalities Act, the Human Rights Act, the Care Act within that, all the relevant legislation. Can't go against the legislation, obviously. Co-produced with residents, because again, it's talking about residents is who you're applying that vulnerability strategy, so co-produce it with the residents, and consider any future good practice guidance that we publish, obviously, following engagement and consultation. Specific reasonable adjustments policy, or if there isn't a specific one, really good explanation as to where it is and where people can find it. What you want is a situation where somebody knows where to find out what the landlord's policy is on reasonable adjustments so that they can find it easily and they can say, this is what I need, and under this policy, this is what I am going here with this. Test the vulnerability and reasonable adjustment strategy and policies against the 3 R's on vulnerable residents. Do they recognize it? Is it respond? And do they record? So do those strategies and those policies ensure that anyone who raises an issue, it's recognized instantly, it's responded to, and that there's records kept of what it is that the person has raised. Because if any of those 3 things didn't happen, it hasn't worked. Introducing minimum staffing training requirements like training on dementia, training on customer care, mental health, learning disabilities, sight and hearing loss. These are really common situations that happen as people age, sight and hearing loss. So ensure that staff are trained. As the demographic information shows, we have an aging population. That is a reality of what the social housing resident of the future is potentially going to be experiencing. So make sure that staff are trained on the reality of that. Consider having a dedicated task force for vulnerability. We completely accept that that might not be something that's financially viable for people, but have a look at it and audit your reasons why not if it's not something that you can explore at this time. Maintain accurate records of vulnerabilities. I can't stress this enough, and the Knowledge and Information Management Spotlight report really talks about this. If the records are not good, you essentially don't have the knowledge. So maintain those accurate records, including the temporary ones, and remove the temporary ones when they are no longer relevant, and individual checks. Use the mandatory checks. We've said this before in previous spotlights, like the annual boiler check, as a touch point opportunity to undertake welfare checks with the residents as well. So again, the Kim report talks about recording vulnerabilities, keeping them up to date, easily accessible, shared appropriately, working with partner agencies, signposting and referrals, clearer explanations, understand the resident's perspective, and work with them to try and find a solution. Adhere to communication needs and preferences. And it goes without saying that anything you do has to be fit for the future, has got to involve knowledge and information management. It is the silver bullet to ensure that you are fit for the future. So there are pressures from every direction on social housing, as the Chief Medical Officer's annual report, the NHS, social care, central and local government, everybody must start planning more systematically on the basis of what the population will be in the future and where it will age to, rather than what was the demand 10 years ago. The Marmot Review, 10 years on, sets out regional inequalities in health, healthy life expectancy, and the resulting effect of people's living conditions on their health. Police, firefighters, social care, housing, and early years workforces have all developed their approaches to tackling health inequalities, and social landlords need to do the same. The demand for social housing in rural areas, for example, is growing at over 10 times the rates of that in towns, but only a quarter of the social housing stock in England is in rural areas. So what are we going to do about that? How is that going to handle? How is that going to, what are we going to do to address that as well? So you need to look at the tackling health inequalities and the infrastructures for where people are going to be living in the future. Carry out your own resident of the future forecast for the next 10 years. You know who's in your properties now. You know how the allocations policies are. You know who's going to be living broadly in your homes in the next 10 years. What does that look like? And are you ready for that? Draw upon the available information and identify where the gaps are now and start working to plug them now. The aging communities, particularly in the rural and coastal areas, and again, like I said before, there is less housing in rural areas than the actual demand as well. With reference to Professor Whitty's report, devise that action plan for what you need to start putting in place now. We've also specifically made a recommendation that we want to establish a new Royal Commission. So seeking to re-establish housing policy as a health intervention, knitting together back health, housing and human rights, and proposing a long-term strategy for social housing. We've asked that accelerates the Better Social Housing Reviews plan for a thorough audit of all social housing in England and residents that live in those social houses. We've asked that it reviews current and recommends new allocation guidance to local authorities so that there are record keeping requirements and data sharing agreements with registered providers. Again, for those of you who may remember, data sharing between local authorities and registered providers was a nuance within the noise report that when we investigated a couple of years ago. So data sharing agreements with registered providers and other agencies on tenant vulnerabilities and reasonable adjustments, so that you, from the residents' experience, it doesn't matter who you tell to what, the agencies are talking to each other and there is a holistic approach to the situation. We've also asked that we include within a new standards framework for professional guidance on following the Equalities Act 2010 and making reasonable adjustments. So new standards framework for professionalisation, making it clear that that is part of a housing professional's role, is how to follow the Equality Act and how to make reasonable adjustments. We've also said that we want the overall relevance of general needs as a label to be reviewed, because the changing demographics within social housing tends to lend itself to the fact that general needs is actually causing some confusion as to whether people in those homes have needs at all. And we've clearly said, and we will repeat it now, general needs does not mean no needs. The needs profile of people being given supported housing looks awfully similar to the needs profile of people giving general needs housing. And a key theme is the importance of interagency working. Within this particular investigation, the Family and Homes Change Project found evidence that many families who experience housing deprivation are also in contact with social care professionals. So what we've also asked for that is that because social care policies and housing practice is not always sufficiently aligned, we are recommending that more holistic approach so that social workers can address housing needs and housing professionals' decision-making can support family welfare. And we want to do that. We want to introduce legislation which provides a legal framework for vulnerabilities and places that mutual duty on agencies to cooperate with each other, so that social housing providers and social services are talking together, they're sharing information together, they're coming up with solutions together. And we want the Royal Commission to support the sector to capture that information on a full range of vulnerabilities across the sector, because that will inform the strategy for regeneration of social housing and the funding required so homes are appropriately designed and adapted for the people who live in them, not just now, but in the future. And I think, she says, drawing breath, I'm going to stop there and ask for questions.
Fantastic. Thank you so much, Rebecca. That was a very, very incredible run through of that report. As Rebecca said at the top, I would definitely read through the report. It's the best way to kind of get in amongst it. And we do have on our website as well, our Centre for Learning workshops and e-learning, which will also help you to kind of get a kind of better understanding and help your staff train in some of these areas that we've talked about before. I appreciate that. We've kind of run over a little bit, a couple of minutes. So we're just going to take, just for the next 8 minutes, we're just going to take 5 questions, and I'm going to ask the panelists if it's okay just to kind of do really brief answers back to those questions. But I feel that as we've had the questions, it'd be good to kind of to go through them. So the first one, 2 people have asked this, and Rick, if we could come to you first, if that's okay. Anna Henderson and Chris Middleton both asked around if there's been any formal response to the request for convening a royal commission yet, and kind of what the plans are there.
Yeah, thanks, Anna and Chris, for the question. So part of it is who creates a royal commission, which is an interesting question in itself. So the report has been shared with the Department for Levelling Up and Communities, and they've looked at the report and the recommendations, and I'm sure they've shared some advice with ministers. We haven't heard anything formally back on that. In the sector, I think I've seen a real range in responses and some really encouraging responses, and a recognition that if you want a long-term plan for housing, you need a vehicle, a structure through which to formulate that plan. So I've seen some really, really interesting and positive responses from the sector, and actually thinking this afternoon I'm meeting with an academic, Michael Marmot, who produced his plan around health and the relationships with housing this afternoon. So I think it's definitely feeding into that debate around these issues, and we'll wait and see what happens. But do note there hasn't been a royal commission this century, so they aren't quick and frequent.
Yes, thank you very much. Yeah, I'm sure that you'll hear more from us as we kind of progress it. And the next question we've had is was from Rebecca Blunden, and she said, "How can poor culture in management be assessed?" I assume it's kind of in relation to some of the recommendations of the report. So I don't know if Rebecca or Zoe wanted to come in on this one about kind of poor culture and its role within the recommendations.
Yeah, sorry, I was pausing there because covers quite a lot. So I was just trying to think of a response. So I think using the recommendations, as Rebecca mentioned about the disconnect between policy and practice, I think that would be a good starting point, and having a culture where disconnect is identified. We talk a lot in the report as well about the processes, as Rebecca's mentioned, and the people side of things, but that staff need to be supported by senior leaders to be providing that human-centric service. So I think that is one of the main things that landlords should be looking at from a cultural point of view, sort of how satisfied are they that they are providing that human-centric service, and if not, what are the barriers?
Thank you, Zoe. The next question is from Mary Walters, and she says, "Is a vulnerability strategy the same as safeguarding policies, or does there need to be a difference?" And a couple of people have kind of asked kind of fairly similar questions around this as well. So Zoe or Rebecca, please.
Yeah, so the short answer is that no, they're not the same thing. Somebody can be vulnerable but not meet the definition of safeguarding, because it's important to remember that safeguarding is a defined process under the Care Act, so is actually a legal process. So just because somebody is vulnerable doesn't immediately mean that they're going to meet that threshold. So there should be separate processes. They do, of course, can overlap, and there is a crossover, but it shouldn't be assumed that they are always one and the same thing.
Thank you very much. And the last question that we're asking this is from Susan Dutteroy, and I think it kind of reflects something that maybe came through in the call for evidence from landlords. And it's just wanted to know whether vulnerability or disability needs to be recorded, as this is viewed as special category 2 sensitive data, and our data protection officers are very concerned, and whether a recording of the reasonable adjustment would be sufficient instead.
So the most important thing that is captured is what it is that the resident actually needs. So I can understand a reluctance to go into great detail, but with any capturing of data, it needs to be specific and targeted and linked to a purpose. So absolutely, there shouldn't be excessive information about any sensitive medical information and conditions, or certainly no personal opinion. But there does need to be a way of identifying those additional needs and individual circumstances. But the most important thing in that example that's been given is that the reasonable adjustments have been captured, because again, that is a legal process and there is a legal responsibility to do that. But just in general terms, even if it's not a reasonable adjustment, it should always be recorded about what it is that the resident needs. And we stress that throughout the report, that that's the most important thing.
Fantastic. Thank you so much. And I say, once again, a massive thank you to Rebecca for the presentation, for Rick and Zoe as well for answering those questions. I'm pleased to see kind of so many people in the comments finding it really useful. The recording and the slides will both be on the website very shortly. As I say, our Centre for Learning has e-learning and workshops that will help you kind of answer some of the kind of questions that we may not have been able to come to. So thanks again for attending. We really appreciate it, and really appreciate you kind of getting engaged with the report. You can find it on our website and you can download it, share it around the organisation. We really feel it's a publication that everyone should be reading. So thank you again, and we'll see you soon, I'm sure.